What's up, Boonies? Well, the court has uploaded the documents that Sarah gave to the judge yesterday in regards to her motions. So I thought we'd open these up, take a look at them, and go from there. Alrighty then. Let's first look at what she sent over. 6 pages. I'm going to look at this from 814. It says correspondence filed from defendant to the judge. You guys know what it's going to look like. It's all handwritten. In the Circuit Court of the Ninth Judicial Circuit in Fort Orange County, Florida. Motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense comes now. She wants reasonable fees for the neuropsychologist. These services include the review of documents and physical evidence, writing of reports, travel and trial testimony. As grounds, the defendant states the following. Defendant is charged with second-degree murder. Defendant has been educated, indigent for cost. Wait a minute. Of course, she has to add her own. I always have to double check. She always adds her own little stuff in here. Defendant has no income and cannot afford the services of a neuropsychologist. You didn't have any income other than Brian before you went to jail. A genuine issue exists related to this case, which will require the assistance of an expert witness in the field of neuropsychology. Defendant is without funds and does not have the ability to pay the cost associated with an expert witness to assist in the defense of this matter. Therefore, she requires the assistance of the state of Florida to guarantee protection of her rights to the process and effective assistance of counsel. Oh, I'm so glad I don't live in Florida anymore. I'd be so mad knowing that I'm paying for this woman's defense. Counsel has contacted neuropsychologist Dr. Hyman Eisenstein. Her previous attorney had semi-hired before Padilla. Padilla was the one that stayed on her case probably the longest, and he was, I think, the second attorney, and I believe he was the one that she was paying for. He got a lot of stuff done. But he had semi-hired, he was already taking depositions from a psychologist by the name of Dr. Charles Heller. So she wants to start from scratch. I wonder, since they may have already paid for this other psychologist, are they going to pay for this one? Let's see. Gosh, I swear sometimes in covering Sarah's case, I feel like I'm going in circles and I'm saying the same thing over and over again. But I think it's just because it's Sarah's case. Ugh. So I apologize if it seems like that, because I'm not. This is new. This is new stuff. Defendant intends to engage in the services of Dr. Hyman Eisenstein. Dr. Hyman Eisenstein graduated from the University of Chicago Division of the Biological Sciences, the Pritzker School of Medicine in 82. He works in Miami Beach, Florida, specializing in psychology. Defendant seeks permission to allocate funds for Dr. Hyman Eisenstein's services at a rate of $300 per hour for all work performed on the case except travel time bill at $125 per hour with an initial cap of $15,000. She wants $15,000. Now, they've already given her 10 towards, they've given her a cap of 10 towards the investigator, plus any reimbursement for all reasonable and necessary related expenses, including but not limited to the travel expenses, lodging, meals, mileage, postage, shipping, and document reproduction, and is a service provider with the JAC. I love how she throws that in there. Why don't you put that in a new sentence, Sarah? This person is a service provider with the JAC. Now, here's a good question for you guys. She wrote this motion, right? She says she has not gotten her documents. How did she know? The documents that she's saying she didn't get was that JAC packet. I'm pretty certain that's what she's saying she had not received. How did she know he was a JAC service provider? I think she's freaking lying in open court. I really do. Well, we know she is, but defendant cannot properly prepare for trial until expert analysis is complete. Delay, delay, delay. Defendant has attempted to request his evaluation through her previous appointed attorneys without success. Okay, they already started this. Okay. Based on several factors to include the attorney not being able to locate the proper specialist in this field of neuropsychology, the willingness of the neuropsychologist to work the case, and the willingness for JAC to pay for the said neuropsychologist. Defendant believes that her pattern of behavior stems from a lifetime of mental and physical abuse and believes that she cannot have a proper defense without a neuropsychologist who can evaluate her exposure to this trauma. We do not know what Sarah's home life was before growing up. We know her parents are deceased. Is she pulling a Casey Anthony and blaming it on her parents now? Let's see. A neuropsychologist specializes in understanding the relationship between the brain and behavior. Given the complexity of the defendant's mental health history, it is critical to assess her cognitive functioning and mental state to determine how these factors may have influenced her actions. Wherefore, the defendant, Sarah Boone, by way of pro se, respectfully requests to this honorable court, in conclusion, for payment of costs and appointing neuropsychologist to assist the defendant in preparation of the defense. And she does the oath. Sarah Boone. Certificate of service. So we just looked at that one. This is the order from yesterday's hearing. The defendant and state agreed to an alternative arrangement as placed on the record on August 14th of 2024 regarding the viewing of the state's physical evidence. Tendered in open court on August the 9th of 2024, the state shall prepare for all parties to execute a notice of reflecting when the evidence viewing took place and the length of time that the evidence viewing took place. The state shall file with the court the executed notice after the viewing of the state's physical evidence takes place. Defendant's request regarding extending the laptop time has been agreed to by the Orange County. I think they meant to put jail at the end. The times have been extended as follows: Sunday through Thursday, 8 p.m. to 10 p.m., and Friday through Saturday, 8 p.m. to 11 p.m. She's really getting special treatment. Nobody's going to like her there at all at the jail. This is in addition to the times outlined in the memorandum from the Orange County Corrections Department Security Operations. Defendant's request regarding the discovery that was provided to the court on June 28th and keeping the discovery in defendant's possession was addressed to defendant's satisfaction on the record on August 14th. The balance of the defendant's request cannot be accommodated for the reasons placed on the record on August 14th. Judge is so done. The judge is so done. All right. I didn't open that one up for y'all. I want to open it. Let's see. Look at this other order. This other order this is the one where he's like, denied. Denied. This cause came before the court on August 14th on the defendant's or tenant's motions for closure of the state's physical evidence viewing. This is just all, it doesn't matter because they came up with a new game plan and they're going forward. They're going to meet in private. They're not going to meet in the court, so they don't have to worry about the media being there. But I want to hear why he denied it. So this is what he says about why he denied it. Defendant has failed to meet the burden of producing evidence and proving by a greater weight of the evidence that closure is necessary as required by Miami Herald Publishing Company versus Lewis. The defendant's requested closure of the state's physical evidence reviewing the state and defendant is set for September the 3rd at 9 a.m. is denied. Okay, let's go back over here. We got this motion. The Orlando Sentinel moves to intervene in the action for the limited purpose of opposing closure of judicial proceedings. I think I already looked at this, didn't I? Is this the one I read already? I think it is. Yeah, I guess that's it. Not too much, but I did want to keep you guys updated on what was on the record. I've looked at everything up until the 14th, which is what we just looked at. So technically, that 9/3 is not going to happen. They're going to do it in private, and we're not going to see anything until September the 26th. We got a long way to go till Crazy Sarah's next hearing, I think, unless something pops up. I do want to show you guys one thing really quickly. Since we were discussing Sarah's background, let's name into this. So I found Sarah's yearbooks. Yes, I did. Now, this was her as a freshman over here on the top left, and this was her as a sophomore on the bottom right. And Guess what? She was a member of the Latin Club. So as I go through her yearbook, there was really nothing special about Sarah. The only additional photos of her outside of her individual school pictures here was the fact that she was in this one huge photo with everybody else. Now, let me go to one other thing. Now, in her senior year, again, nothing special. She didn't really have a whole lot. They did have this area, though, in all the pages that they were focusing in on the senior. They took a quote from Sarah. They asked, surviving the year, what do you do to relax and relieve the stress of your senior year? And Sarah said, I go to the beach and just relax in the sun. I also go to my boyfriend's house and just bum around and run a couple of movies. Sometimes I will play my guitar. Oh, look, guys, she was even a lazy ass in high school. Sarah. That is all for today on Suitcase Sarah. More to come very soon. You guys make sure you are going into the YouTube community area of my page, checking out. I'm posting a lot of extra stuff to help you guys keep up with things. So please don't forget to go in and check that so you don't miss a thing. Y'all have a blessed day.